Hello friends, you're welcome to the Key Point. If this is your first time you're joining us in our channel, please kindly hit on the red subscribe button below the video, and please don't forget to hit on the bell button beside the subscribe so you won't miss any of our videos. Thank you. People's Democratic Party presidential candidate in the last presidential election, Alhaji Atiku Abubakar, has written to President of the Court of Appeal on the need not to allow his petition at the Presidential Election Petition Tribunal to be cut by constitutional timeline. The tribunal had on August 21st reserved judgment in the petition filed by Atiku against declaration of President Muhammadu Buhari as winner of the 2019 presidential election. The five-member panel of the tribunal, led by Justice Mohammed Garba, reserved judgment after the petitioners and respondents adopted their final written address. The respondent in the petition are the Independent National Electoral Commission, Buhari and his party, the All Progressives Congress. Justice Garba, while reserving judgment on the petition, had informed parties that the tribunal will communicate to them the date verdict will be delivered. Sequel to Section 134, Subsection 2 and 3 of the Electoral Act 2010 as amended, the hearing and judgment in petitions at the tribunal of first instance are supposed to be concluded within 180 days. On what prompted the letter to be sent by Atiku legal team said such a significant petition, which has caught the attention of Nigerians and members of the international community, should not be allowed to be truncated by constitutional timeline at the tribunal. The PDP and Atiku had on March 8 petitioned the tribunal over the February 23rd election in which INEC returned Buhari as duly elected. However, following what he considered as perceived foot dragging by the tribunal in hearing his petition, Atiku had on June 2nd first petitioned the Court of Appeal, alleging a deliberate ploy to truncate the constitutional timeline of the Presidential Election Petition Tribunal. The petition came 11 days after the President of the Court of Appeal and its while chairperson of the 2019 Presidential Election Petition Tribunal, Justice Bulkachuwa, recused herself from the tribunal following the petition of the PDP and Atiku legal team. The PDP and Atiku, among other things, had said Justice Bulkachuwa, being the wife of Adamu Bulkachuwa, a prominent card-carrying member of the APC and senator-elect for Bauchi North Senatorial District, which is a political party involved in the suit, will be biased in deciding the case. After Justice Bulkachuwa recused herself from the case, it took her over 2 weeks to appoint a replacement, which made Atiku to express concerns over the delay in her finding a replacement for herself on the tribunal. The PDP candidate, in a letter through his counsel dated May 31st, 2019, urged the President of the Court of Appeal to appoint a replacement forthwith. According to him, the tribunal has a timeline to prosecute the petitions, adding that 76 days have already been expended out of the 180 days allowed by law, as seen in Section 134, Subsection 2 and 3 of the Electoral Act 2000 as amended. The petition stated, "I am one, Silas Joseph of the counsel in the legal team, prosecuting the above petition on behalf of the petitioners." Okay guys, before we proceed, I want us to look at this, the case of Atiku from the PDP, the presidential candidate of PDP in the just concluded 2019 presidential election. The case has been delayed for a long time now, and there's a saying included in the letter that Atiku said he has noticed a foot dragging in the judgment. That simply means things are not flowing the way it's supposed to be. The judgment is not given the way it's supposed to be. Now, I want to ask a big question. Do you think Atiku and the PDP still have any hope in winning in the tribunal? Kindly hit on the comment section and drop your comment what you think about this story. Thank you.